Yes, thank you, Mr. Chair, and I will start with 1957.
Okay, that is our item number 3.
All right. So I'd like to thank the chair and committee staff for the work on this bill, and I'm going to accept the technical amendments. However, I am going to keep the language in the bill that says body-worn footage should be released after 60 days. Current law allows law enforcement to release body-worn camera footage. Well, actually, it varies from jurisdiction to jurisdiction. Some of them say it's public record and therefore it can be released. Some of them say it's not public record. Among those who say it's public record, however, law enforcement can always cite that something is under investigation. This is commonly done, and as a result, no footage is, or very little footage is ever released. This is why I kept the 60 days. We have all seen body-worn cameras be effective, but we also see how trust can be destroyed when secrecy prevails. In particular, in Chicago in 2014, a teenager was shot 16 times. There was police video. However, that video was not released. Finally, it was released 13 months later. And when it was released, they decided, oh, yes, we really should indict this officer for murder. And the police chief was fired. But 13 months is clearly too long. I don't know that 60 days is the right amount of time, but I've asked for input from others and really haven't gotten it. We cannot let what happened in Chicago happen in California. A year is clearly too long. Currently, there's a lack of statewide policy regarding the release of body camera footage. This leads to strange situations where, for example, in LA, they were sure that some body camera footage was going to exonerate an officer, but since they weren't releasing anything else, they didn't want to release that. AB 1957 would establish a statewide policy to govern the release of body-worn camera footage by addressing 4 major points. One is that it allows the local governing body to view the body camera footage in closed session. It allows a judge, if there is an official prosecution, to decide on the release protocol of the footage. If prosecution is not pursued, then footage will be released after 60 days. Footage that relates to crimes of domestic violence, crimes that include minors, and statement of witnesses at the scene of the crime will not be released for public viewing. And again, I'm willing to talk with the opposition on any of these issues. Earlier this year, I heard the listening tour. Again, I talk with everyone, but I just haven't gotten any feedback. I look forward to continuing working with concerned groups as the bill moves forward. Thank you.
Thank you. Any witnesses in support? Seeing none. Anyone in support? All right. Opposition.
Mr. Chair, members of the committee, Jim Ewart with the California Newspaper Publishers Association. We don't have a position yet on the bill, but we've been working with the author and his staff on language as the bill is moving forward. We do have some concerns about how the interplay with the new language deals with Brown Act considerations about closed sessions that may not normally exist or that don't exist now in the law, and how that's going to operate. But we think he's on the right track, and at some point in time, we're hoping that we can come on board in support of the legislation. Thank you.
All right. Others who are maybe not in opposition or support, but comments?
Mr. Chair and members, Kevin Baker from the American Civil Liberties Union in California, very much in sympathy with our friends at the newspaper publishers. We think the author is trying to walk a fine but appropriate balance between public record disclosure, which we think is appropriate, with some protections for privacy, which we think is also appropriate. It's somewhat of a delicate balancing act. The author is trying to get there. We're trying to be of assistance and look forward to participating in further discussions. Thank you.
All right, thank you.
Yeah. Chair and members, Jonathan Feldman with the California Police Chiefs Association. We are actually in opposition.
Yeah.
Sorry about that. Working on things. Our primary opposition is the fact that after 60 days, the investigatory footage would be released under this bill. The California Supreme Court has ruled that investigatory footage under the PRA is always exempt from release. That once that footage has been deemed part of an investigation, it is always part of an investigation. It has to do with, not compromising that if there's appeals, if there's additional investigations down the road. So that is our primary opposition to the bill. It was a 1993 California Supreme Court case, Williams versus the Superior Court, and it's been upheld to this point. So that's our opposition. We request a no vote at this time.
Thank you. Others in opposition?
Dane Hutchings with the League of California Cities. Again, I'm sorry I jumped out of order here, but I'm a little bit of a tweener myself. We have not taken a formal position on this bill. We'll be adopting likely in a post position at our upcoming board meeting. Absolutely appreciate the amendments that the author has taken thus far with regards to changing it from an investigation to an indictment, sort of tightening it up a bit. A couple of things that our folks have concerns with. The judiciary process takes away some local control and discretion, given that now a judge is responsible for the manner of which the video is released and all those other details. And then again, align our comments with our partners in law enforcement with regards to the timing as to which those videos can be released. I think 60 days is a little too soon, particularly with regards to continuing investigations. Thank you.
Thank you. Anyone else in opposition? If you could just give your name and your affiliation, please.
Jeremy Hangson with the California Civil Liberties Advocacy. We regretfully oppose. We did speak with Mr. Quirk's office yesterday about some amendments, and the discussion was promising, but...
Okay, and thank you. We're at this point just taking name and affiliation, not further testimony.
Ivan Altamura on behalf of the California Statewide Law Enforcement Association, Fraternal Order of Police, Long Beach Police Officers Association, Association of Orange County Deputy Sheriffs, and the Sacramento County Deputy Sheriffs Association. We are all opposed to the bill.
Thank you. Anyone else in opposition? All right, seeing none, we'll bring it back to the committee. And Ms. Quirk, thank you for working with us. I do understand that you're not going to, at this point, take the amendment as recommended. And from this committee standpoint, from my standpoint, I think that's fine. But I think you also understand the sensitivity around an ongoing investigation. I agree, as we worked through this with your office, that definitionally that's been a little bit difficult. But with your continued work on that, I think there's definitely a place that you can get to for some success on this bill. But in the case of this bill and the analysis, I'm still recommending that it pass out of this committee as amended, with that one exception to appropriations. Other comments, questions, Mr. Wagner?
Well, thank you. We dealt, I think it was last week, it might have been the week before, with a body camera bill, I believe, by Assemblymember Lowe, and it, if memory served, went somewhat in a different direction and had more privacy protections. I'm wondering if you've had an opportunity to talk with him, how is what you are doing and he is doing compatible? And if you haven't, that's fine. I understand that.
No, we have talked. I believe we are compatible because what his bill, now there's another bill by Cooper where I'm not compatible. But there is
I'm not talking about the bill.
Okay.
Understand.
With this one, I believe we are compatible. As I recall, the bill you're talking about says you shouldn't show the death of a police officer. I think that was one of the major constituents of that. Actually, even with the Cooper bill, I don't know what he gets. No, definitely not Cooper. All right. I think with the Lowe bill, we are compatible. He's looking at not releasing filmage of the death of a police officer. I don't think that applies here.
So you're going the other direction, film of the bodily injury or death inflicted by the police officer,
yes,
right?
That's correct.
Though, don't we have some of the same privacy and just civility concerns? I mean, if you are the victim or the victim's family, how are they consulted or brought into whether that sort of material should be released?
I think you'll find that every time that's happened, the families have asked for release. I don't think you'll find an exception to that. If you do, let me know. Also, I know you are a very bright person. If you can figure out a way, either an optimal time for release or a process. The problem is investigations go on forever, and if you can figure out a way around to square that circle, I'd appreciate it. Thank you.
Not that bright.
Okay, thank you.
I'll take the compliment. Thank you. All right. Thank you.
All right.
Other questions, comments from committee members? Seeing none, Mr. Quirk, you may close.
I ask for your aye vote. Thank you.
Thank you. So I'm still looking for a motion. The motion is do pass as amended to appropriations. Mr. Holden's making the motion, and a second. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? No. Wagner, no. Alejo? Aye. Alejo, aye. Chow? Chu? Gallagher? Garcia? Aye. Garcia, aye. Holden? Aye. Holden, aye. Mainshine? Aye. Mainshine, aye. Ting?
Needs one more. We'll put that bill on call.
Thank you. Shall I go to the next bill?
Please do. AB 2027, our item number 4.
So, in this bill, first of all, I'd like to again thank the chair and the committee for their work on the bill. AB 2027 requires that if a victim of human trafficking has been cooperative, a certifying agency must certify victim cooperation on the applicable form so that a victim of human trafficking may apply for a T visa to temporarily live and work in the United States. A cooperative victim, by definition, means to the investigation or prosecution of that qualifying criminal activity if the victim has not refused or failed to provide information and assistance is reasonably requested by law enforcement. So the point is here, the person has to be cooperative, and there's a definition for it, and if they don't meet it, they don't get the T visa. AB 2027 will increase public safety by encouraging these survivors to report the crimes they were unjustly subjected to. In October, there was a human trafficking informational hearing in public safety, and several individuals brought to our attention the lack of focusing on trafficking for labor. That's why I'm introducing AB 2027. Trafficking for labor is several times more common than trafficking for sex. In addition to the harm that this crime causes its victims, secondary consequences of human trafficking can severely affect our own communities. The impact of human trafficking on California's communities includes child exploitation, public health problems, and depressed wages. Trafficking is an insult to human dignity and an assault on freedom. I respectfully ask for your aye vote.
Thank you. Your witnesses in support, please.
Yeah. Jonathan Feldman with the California Police Chiefs Association. This is the one that I'm in support of.
It's good to keep that straight.
Yeah, I know. It's going to be a long day. But, police are part of their communities, and we rely on our partnerships and our relationships to do our job. And so as this bill provides immigrants a feeling of security when they come to us to talk about the crimes that they've been a victim to, as they can come forward and assist us in actually going after and apprehending human traffickers. And they have the assurity that they're not going to be prosecuted, that they're going to be able to be protected and stay here and work with us is a great thing. And so we fully support this bill and thank the Assembly member for his leadership on this issue.
Thank you. Other witnesses in support? Seeing none, any opposition? Seeing none, I'll bring it back to the committee. Questions, comments? Ms. Garcia.
I'm going to move the bill. Just want to thank you for your work on this. One of the Women's Caucus priority this year is human trafficking, and both the Women's Caucus and our male colleagues are working hard on this. So thank you for your leadership on this item.
Thank you. There is a motion and a second. The motion is due pass to appropriations. Further questions, comments? Seeing none, Mr. Quirk, you may close.
I ask for your aye vote. Thank you.
Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Alejo? Aye. Alejo, aye. Chow? Chu? Gallagher? Garcia? Aye. Garcia, aye. Holden? Aye. Holden, aye. Mainshine? Aye. Mainshine, aye. Ting?
That bill is out.
Thank you.
Thank you. Saw Mr. Bloom, Ms. Burke were here earlier. Doesn't look like they are here. All right. So, Mr. Wagner, if you'll take over, let me I've got a couple bills to present.
All right. Item 10, AB 2879, and 11, AB 2880. Take them in whatever order makes you happy.
Okay. Thank you. Let's start with AB 2880, the state-owned intellectual property bill. As everyone's aware, there was a trademark dispute at the federal level involving federal parks, Yosemite National Park, which used to be a state park. I think if it still was a state park, maybe it wouldn't have been in that problem, but that's not the point of the bill. But what we are trying to do is make sure that we're clarifying existing law to provide that a public entity can own intellectual property and that has a responsibility to manage that intellectual property and cannot dispose of it by contract or otherwise without going through a process with the Department of General Services. These are assets to the state of California, and I think are very important for us to protect and not give away in the way that the trademarks really were given away in the Yosemite National Park instance. So that's what this bill does. And with that, I do have witness in support.
First witness?
No. Okay. I guess we had an auditor here, but
well, let me ask: Are there witnesses in support? All right. There's a motion for the bill. Is there a second? All right, there we go. Mr. Alejo, second. Witnesses in opposition.
Go ahead.
So I'd like to thank the chair and the vice chair and members of the committee for allowing me the opportunity to speak to you about AB 2880. My name is Ernesto Falcone. I'm the legislative counsel for the Electronic Frontier Foundation, a San Francisco-based nonprofit civil liberties organization that's dedicated to protecting consumers, consumer interest, innovation, and free expression in the digital world. My organization brings with it more than 25 years of experience in representing the interests of technology users both in courts and in the policy arena. I wish to emphasize that EFF's opposition is specifically in regards to the broad express grant of copyright authority to public entities within the bill and not with the other intellectual property provisions or contractual provisions within the legislation. This is because such a broad grant of copyright authority carries significant issues in terms of government openness, citizen speech, and harms the public's interest in maintaining a robust public domain. We find that the exemption for the California Public Records Act insufficient to address these concerns, given that within the same provision within the legislation, there is an express reservation of all rights granted from a federal copyright. And so what are those rights? At the moment of creation, a copyright grants the rights holder, in this instance the public entity, the power to deny others the right to make a copy, to distribute a copy, to publicly perform or publicly display a work, to create a derivative work from that work as a source, and to perform that work over a digital audio transmission. Infringing on one of those rights requires an individual simply to take one of those actions without the permission, and absent a fair use defense, they will be liable. That is all it takes. A violation does not require an intent to commercialize. It does not require an act of negligence. It's just the action alone is sufficient for liability. And given that this legislation promotes the registration of state-owned copyrights, the liability can come in the form of statutory damages, which are entitled to registered copyrights. And that reaches the range of damages in the tens of thousands. This presents not only a significant issue for the public to learn about disclosed documents, but it chills speech with a fear of a high cost of litigation. In essence, the bill allows the citizen to obtain the document through a CPRA request, but also retains that right granted under copyright law to suppress the dissemination of that document. Fair use does not remedy this harm simply on the fact that not all uses will be found to be fair uses, and each would have to be litigated in a court to exercise that right. Lastly, it needs to be recognized that extending copyright over all works protected by public entities is a dramatic departure from the status quo. As noted by the courts, the state legislature has only granted 5 specific and narrow grants of copyright authority and in recent times. And by shifting all remaining future works away from the free access to the public domain, the bill would sacrifice California's position as one of the most open access states in the nation, and citizens would no longer be entitled to free access to materials that are funded by taxpayer dollars. So with that, I express a sincere hope that we can work together to address this concern, and I thank you.
Thank you. Additional witnesses in opposition? All right, since we've seen a lot of tweeners, no tweeners. All right, let's bring it back to the committee. Questions or comments from the committee? All right, I'll try. Can you address the copyright concern?
I'm very happy to, because this does not, copyright is a federal right that's given to us. It goes back to the Constitution that first establishes rights in authors and inventors. State and public, even the federal government, cannot create copyrighted works in the same way that a private individual can, because since they're doing this, since it's a public employee and since it's done with public money, it is by definition public domain. So those are not items that are created under the copyright statute. There are times when the state will own a copyright, and that is if under some contractual arrangement, someone already owns a copyright and transfers it to the state. And in that case, the state then owns that copyright and does have the ability to manage that copyright as any other copyright holder would. This bill does not create any additional way or right of the state to create a copyright. Those underlying laws remain in effect. This is mostly aimed at intellectual property that happens to be in the possession of the state. And copyrighted works, by their definition, are effectively made public under the copyright statute so that they're viewable and people can see what they are. The copyright itself prohibits those copyrighted works from being copied, disseminated, or derivative works being created from them other than as allowed by the state. Those laws we're not touching in this case. This would really create a situation where where Department of General Services would have to manage. They come up with rules on how we manage that portfolio. And I think you'll probably find that at the state level, there's probably not that much in the way of copyrighted or certainly patented works. Trade secrets are not going to apply in this case. What we're really aiming at are the trademarks. And the state, in fact, under the Lanham Act, is authorized to own trademarks and manage trademarks. That's something that the federal government and state governments do on a regular basis. It's an it's an unfair competition statute, which is what the Lanham Act really is. The state does have the ability to control then that trademark, and especially in that control, prohibit someone from taking commercial advantage of something that the state deems important enough, like an historic trademark, to be something that the state wants to control for the benefit of the public. That's how this works. I'm actually happy to work with the opposition here, the EFF. I don't disagree with their concerns. I actually wholeheartedly support their concerns about public entities controlling or managing in an inappropriate way intellectual property. But I think because we cannot change the underlying way that copyrights attach and copyrighted works are created, all we're doing is saying that if there's an intellectual property, the state has to have a mechanism to manage that in the best interest of the state. And again, public domain works or works that are for the benefit of the public, I think it is in the best interest of the state to allow dissemination and usefulness of that across the board. So that's what we're trying to do here. I don't think this state or this bill reaches unnecessarily or reaches at all into the way copyrights are formed or attached under the federal law, but merely make sure the state manages that intellectual property portfolio appropriately. And so if there's something that the Electronic Frontier Foundation, I'm happy to kind of tweak this to make that clear, but the way I read this, I think that's clear because we obviously have no ability to reach in and change the constitutionally granted right of copyright, nor the statutes that are created at the federal level that dictate how copyright's attached and how they're used.
Right.
If I may.
Additional questions? I'll let you work with the author to address the issues that he's raised. Thank you. Seeing nothing else, you may close.
Thank you. I asked for your aye votes.
All right. There's a motion and a second. Call the roll.
Stone?
Aye.
Stone, aye. Wagner? Aye. Wagner, aye. Alejo? Chow? Chu? Gallagher? Garcia? Aye. Garcia, aye. Holden? Aye. Holden, aye. Mainshine? Aye. Mainshine, aye. Ting? Aye. Ting, aye.
The bill is out. Thank you.